Hello everyone, welcome to Cashcroft TV. My name is Kaylin Ashcroft. Thanks for watching this video on Guide to Legal History and Historians. We will be covering the Oxford Handbook of Legal History, edited by Marcus D. Dubber and Christopher Tomlins. This will be the two chapters by Carolyn Strange and Angela Fernandez, tied under Part 2, Conceptualizing Legal History. So Carolyn Strange's chapter is Chapter 13, Femininities and Masculinities, Looking Backward and Moving Forward in Criminal Legal Historical Gender Research, by Carolyn Strange, and Angela Fernandez chapter number 14, Legal History as the History of Legal Texts. So as you might know, I'm particularly for the former chapter, I'm not a expert on feminism. However, if you notice any errors in my information or in any of my videos for that matter, firstly, congratulations, because that's good attention to detail and shows you know the content. But secondly, I'm learning in the process as well, so at least I'm here trying. And I hope that just by listening to this video, you might be directed to the right resources. And once again, if you notice any errors, congratulations. I think that's a good achievement on your own, and yeah, I appreciate you joining me on this journey. And once again, although this is chapter 13 and chapter 14 of the textbook, these videos must absolutely not be watched in order. So if this is your first video, thank you so much. So without further ado, we will begin with chapter by Carolyn Strange. So a little bit about the author and the style of Plutarch's Lives, and we'll do a comparison at the end. She's a professor and the head of the School of History at the Australian National University. She's been in this position since 2021, and she is serving in a 3-year term. She has taught in Canada, including Queen's University, Carleton, and the University of Toronto, as well as in the US, such as Rutgers University, and at Australian universities such as Griffith University and the Australian National University, where she is currently working. She has also worked as well at Murdoch University and Perth University. She has a Bachelor of Arts in Honours in European History from the University of Western Ontario in Canada, and a Master of Arts in Canadian History from the University of Ottawa, and a PhD in U.S. and Women's History from Rutgers State University of New Jersey. Her areas of expertise are history and philosophy of law and justice, North American history, culture, gender and sexuality, law and society, courts and sentencing, criminology, Australian history, excluding Aboriginal and Torres Strait Islander history, and history of philosophy of medicine. She's had fellowships at Warwick University at the Institute of Advanced Study and at Macquarie University in the law faculty, as well as in the University of Sydney in law as well, and as well a fellowship at the Academy of Social Sciences in Australia. Her latest book is titled The Death Penalty for Sex Murder in Canadian History, published by the University of Toronto Press in 2018. She also covers this covers the Confederation up until the Confederation in 1867 until the abolition of the death penalty. So her chapter is in Part 2, Legal Approaches, Conceptualizing Legal History, and it is titled Femininities and Masculinities, Looking Backward and Moving Forward in Criminal Legal Historical Research. So hers is conveniently broken down into sections, so starting with the introduction. She opens up with this quote, law by herself, however. Law demarcates, law bifurcates, slicing the impermissible from the permissible. Simultaneously, it designates who may and may not enjoy its protections and suffer its consequences. Therefore, certain laws on books make explicit sex distinctions, but gender norms find their way into law's application and its language of putative neutrality. Feminists began in the late 18th century to call out the fiction of the neutrality of the law, and every branch has subsequently been attacked by femininity. Those are her words, not mine, pardon me. And still, However, feminists are still looking to rectify the inequality. Law, through its texts and technologies, imagines and acts on women and men, and therefore, in a sense, law creates gender. Feminists in 1970s started first to erode the certainty of the biological and cultural naturalness of unequalness of power. It's in the 1970s. And they have since critiqued the assumptions of the variability of masculinity and femininity across time and place. So there has been pretty much a constant push. However, they recognize there's been a variance over time and space. Critical race theorists and Marxist scholars enrich the analysis by integrating cross-cutting social and economic stratifications. Therefore, it almost came, as she says, from nowhere. The field existed nowhere to now it exists everywhere. There's also cross-disciplinary work, such as the work relating to masculinity studies, which started in the 1990s, started a little bit later, as well as cross-disciplinary studies with critical legal studies, and she says that is an amiable companion for feminist studies. Legal regulation of marriage, divorce, and child custody have touched more lives, she says. However, this chapter will focus on the history of criminal justice and discrimination that might take place in the future. Historians such as Michael Grossberg and Jacqueline Jones for family law, she references, are great sources. Mothers, fathers, adulteresses, and adulterers across different castes, so they're good sources to look at. And also, they take also a deep eye into race and religion, so those are great sources for the topics of marriage, divorce, and child custody. However, this chapter will focus on criminal law, which is different and, as she said, affects less people. However, one wouldn't say it's less important, however. But the thing is, a lot of people think criminal law almost always applies to everyone. Often it uses the term everyone. However, using a hat of skepticism to trace the history of neutrality, one might notice there are differences, particularly in those such as abortion, prostitution, and infanticide laws. This chapter will focus on the intimate murder and rape and compare their study in British and US history. The reason why she chose these two areas, intimate rape, murder, and rape, is one, that research on these crimes predate the 1970s feminist shakeup, so they have not been affected by this research as well, or this push as well. It highlights how political lens has changed the focus from offenses to changing configurations of gender. Furthermore, it leads to the question, how has criminal law made gender? 2, because its understanding of sex is integral to rape but not murder. Therefore, can reveal the meanings of differences between them. For example, also as it relates to intergender versus rape, intergender murder and rape. And 3rd, because both intimate murder and rape involve violence to the body and call into question the permissible and criminal nature of human aggression and victimhood. So, in terms of the chapter, the first section reviews the foundational works and thinking that have caused gender research, have inserted gender research into the study of criminal legal history, and it sets an ambitious research agenda that remains inspirational. Second, the second section considers femininities and masculinities in the analysis of men and women murder. Some cases in which there have been too strongly focused on as identifying women killers as gender warriors. And then section 3, the historiography of rape beginning in the 1970s, showing the variability in perpetration and punishment, and discusses American exceptionalism, where most murderers in Western nation, which is the most murderous nation, Western nation, where race is held out often to explain rape And then, as for the conclusion, it presents challenges that remain and need of review of the current reliance on intersexual model of gender analysis. Furthermore, a more dynamical analytical approach will be presented, and its merits and consideration in capitalization of digital historical resources as well will be mentioned. So this will all be covered. So, starting with part 1, is titled The Spade Work of Exploring Criminal Law's Sex Differences and Gender Dimensions. So she opens up with provocative politics scented the air of the Academy in the late 1960s, led by Europe and the United Kingdom. For example, in 1967, the Journal of Social History, in the article titled Ordinary People of the Past, which was produced 6 years later, 3 articles on criminal law and expressly considered the merits of men's and women's roles, but did not actually use the term gender, but it was the foundational work for feminist legal studies, which essentially started in the 1970s, so 6 years after 1967, after the first publication of the Journal of Social History. In the 1980s, the Journal of Gender and History was founded, and the founders claimed the purpose a compensatory phase of women's history that had supposedly lost its analytical edge, so once again strengthened in the 1980s, and in relation with also included in relation to race, class, religion, and sexual orientation, so expanding upon this in the 1980s. Furthermore, deconstructing binary categories of masculinity and femininity, and became a prime objective during this time. John Wallach Scott's work and his landmark 1986 essay titled Gender and a Useful Category of Historical Analysis used the word useful is a modest understatement, that she says, and because it presents that gender is a constitutive element of all hierarchical relationships, and further presents gender as a primary way of signifying relationships of power, and many sub-disciplines, including criminal justice history, were expanded upon in this area. So John Wallach Scott's work is also integral in this area. So starting with part 2 in the discussion of intimate murder. So that's some of the back history of the area of research. The part 2 is titled Fatal Femininities and Masculinities in Intimate Intergender Homicide. So women who kill are often portrayed as perpetrators as female bluebirds or criminals deadlier than males. So the logic here is that if it's very unlikely that if a woman kills, and if she does kill, she might be an absolute outlier and therefore perhaps potentially more dangerous than men. And women who kill men has always interested writers, but it took the feminists to reveal the femininities of the past. 1977, Mary S. Hartman applied academic skills to demonstrate how gender history could be written through analysis of women accused of murder in her book Victorian Murderesses, published in 1977. And the writer, Carolyn Strange, notes, like Victorian times, typically murders were done through the circle of intimacy, so it was not like perhaps in the case of men, where it might be more likely just some random individual or some it's often through the household or a case of intimacy. And this book also exposed domestic and economic conditions in France and England, and also those that set the foundation for these murders. Anne Jones' Woman Who Killed, published in 1980, expanded on Hartman's work, where women were treated as different or had been previously thought as different due to the masculine biases, and instead violated social, cultural, and religious norms, and they were seen as defiant and rebellious, akin to feminists of her own days. So she actually, in a sense, defended some of these murders, saying that they were defiant, and in fact, many of them might have quantified as feminists, or qualified, pardon me. There has also been cross-fertilization with masculinity studies in the 1980s and 1990s, such as Angus McLaren's The Trials of Masculinity, where a parallel feeling towards women murderesses for cuckold is experienced for men jury members, but not so much for the coward or the brute. So a lot of men who go into jury trial get the sympathies from other men. For example, one might be seen as a brute, or one might be seen as a coward, but these don't necessarily apply to women, where they're all seen as perhaps some outlier, the blue bird. But on the other hand, the cuckold, for some reason, seems to be more appreciated, as we'll see. Perhaps it's because they might be a certain appreciation for women's faithfulness. And therefore, gender impressions are seen as normal and matters as much for men as for women. So that was revealed through McLaren's work on masculinity. Randolph Roth's American Homicide, published in 2009, showed that marital homicides spiked in the mid-19th century, and this correlated with a shift of the balance of power between men and women. So, as higher rates of femicide ironically increased in France, Britain, and the UK due to legal changes strengthening the power of women. So, there is thought where conservative masculine feminine models preserved, there was no rise in intimate femicide rates, and it's thought that men, through anguish, perhaps through the laws they felt they could no longer control the women, there was a spike in murders. But however, about 10% of murders, Cesar Lombroso's description says that they defy the natural destiny as the nurturer of life, so they are thought of as quite exceptional, whereas men are more likely to get sympathy. Carol Smart, Frances Heidenson, Nicole Mann Rafter, Elizabeth Stanko led feminist attack on the social scientists who were oblivious to gender dynamics of lethal violence, yet fixated on race and class. So as we'll see, they're often viewed separately. There's like feminist research and then racial studies, but rarely are they combined. And also there have been fewer subgroups as well within the feminist category, according to these writers. And therefore it's called what's a double deviance. So if a woman is already in the 10%, they're automatically thought to be a crazed murder, kind of going against nature, whereas a man might be more likely to get some sympathy. But two problems emerge with this. It supports Jones's lethal violence as an extension of feminism, so it says that feminists are violent, or for example, if a woman kills her husband, she's a feminist, and that puts a bad picture on feminism. But secondly, it enervates the inquiry into multiple femininities under distinct historical circumstances, so it ignores the variation across different femininities across time, space, and peoples. But therefore is still playing catch up in the lethal notifiers in that men's and women's studies, whereas this has been more detailed studied, for example, with Angus McLaren's work. The task of historians to ferret out history for this purpose of dissection. So this is part 3, moving into rape, men as monsters, women as victims, is the title of the chapter. So, first body of legal historical research on rape constructed by lawyers working on what's called the black letters of law. They set the standards for the proof and sewed in pockets of defense, so what the standards were for convicting someone of rape. Joanna Burke, Rape, Sex, Violence, History, published in 2007, was a statutory definition of rape dated back centuries. However, the word rapist was only acquired in the late 19th century, when the range of sexual identities began to proliferate. And therefore, often it was seen as an affront to male honor and patriarchal investment in female chastity, a crime and affront to reason or against a person. So the term rapist didn't even exist. One would rape someone, but once there was this growth in female or male obsession, perhaps, with female chastity, there was the title of the rapist, and often was targeted towards specific individuals or specific peoples. In the 1970s, Susan Brown Miller's Our Will, Men, Women, and Rape, published in 1975, it was a tool wielded for patriarchal suppression of women, where women live in constant fear from rape, and it failed to treat as a changing social force, and it brought attention to the ignored and trivialized. Later, it proved through empirical studies that there were men's biological drives pushing for causing rape. However, much of this was undocumented, and didn't go into the law, and it was less likely. Mary R. Block in the historical continuity said the historical continuity is not knowing how many women are raped. So even from the research we have, a lot of it is missing, and a lot of it is also perhaps falsified. And there was also a lot of women obviously didn't report this due to their reputation, and particularly at this time when there was a larger, perhaps we might call it, obsession with female chastity, there might have been a less likelihood for them to report it. So it's hard to tell if rape was higher during certain times or lower during certain times based on reporting rates. And the penal frame of rape changed significantly in the 18th century, capitalizing on where rape turned from a capital to a non-capital punishment. For example, in Great Britain in 1841, the legal change led to a higher conviction rate. So if when it switched from capital to non-capital punishment, there was more likely to be convicted. Historian Martin Wiener said approximately 50% of prosecuted are convicted. However, 20% of accused are found guilty. In the 1840s to 1900 versus the early 19th century. So did women feel greater sense of justice? Strange thinks they did, even though perhaps the punishment went down, they were more likely to be found guilty. So they actually perhaps felt a higher sense of justice, even though their rapist wasn't being killed. And therefore, it's seen as sexual aggression versus the patriarchy, in that there's a second can be addressed. The patriarchy can be addressed, but sexual aggression, the biological drives of men, cannot be addressed or are more difficult to address. And castration laws also, similar to capital punishment, did little. So it wasn't just cranking up or raising or decreasing. Well, decreasing the punishment seemed to actually cause for more convictions. Moving to part 3, the ending part. I guess you can put the rape and the intimate murder into part 2. Part 3 is the American exceptionalism and murder. So the unique colonial and national history of the U.S. make it an outlier in the world history of murder and rape. Compared to comparable liberal democracies, the high murder rate, particularly firearms related, have been higher at least since the Civil War. Rape also is exceptional due to the linkage with slavery and nature of racism that transformed in history. However, it did not attenuated racial discrimination after the emancipation, or it only attenuated after racial discrimination after the emancipation. In the 1840s, U.S. criminal justice increased what's called intersectionality, but paid less heed to convictions of men for post-sentencing fate and intimate partner violence. So once the person was convicted, there was less work done or paid less attention to what happened to the individuals after, or what happened to the families after, or what happened to the victims after. There's also the concept of masculine wounded pride amongst Anglo-Americans, particularly in the United States, according to Strange, in that particularly in the 18th century there was a good chance of being acquitted for killing a paramour for a wife or lover, even if they stalked, which would mean it would be first-degree murder. I previously made a video, and one of my favorite movies of all time with Jimmy Stewart is Anatomy of a Murder, where the lawyer defends a man who kills I don't want to spoil it too much, but you're watching this video, it's inevitable. His girlfriend is raped, and he kills him, but they find a law that he was temporarily insane, and he's allowed to be acquitted. And therefore, there's perhaps more sympathy to this sort of thing, and perhaps more sympathy for men as well. But also, this is particularly part of the American exceptionalism, according to Strange, and that Anglo-Americans particularly are susceptible to this idea. And it's perhaps even less likely, for example, if the individual was Irish or Southern European, that they would be acquitted. And furthermore, this varies state by state, where it's particularly stronger and persisted in the South, where there's perhaps stronger family honor ties. In the 19th century, the criminalization of men as a stance by jurors did not take hold with American jurors despite the feminist push. So the criminalization of men was stronger in other Western countries than the United States. Randall Roth's American Homicide, published in 2009, said the degree of alleged perpetrators, an outsider of a community, and the reputation of the couple affected the outcome of men killing their wives and lovers. And this is all supposedly stronger in the United States. And there's also what's called a duty to duty to retreat, which is a historic and enduring white supremacy tactic to prevent blacks from enticing the latter's or the former's love interests. Jeffrey S. Alders notes, I would be no woman if I wouldn't hit him, published in 2015, said abuse was high in white homes, as high in white homes as in black, and the male often through male rage over jealousy. No duty for retreat, but there was no duty for retreat for females, and there was no masculine chivalry for females. So, albeit these defenses existed for men, right or wrong, perhaps more often wrong, these defenses didn't necessarily exist for female, except when it related to their chastity often. There's an unwritten law protecting from abuse for women, however, but often it does lapses into this double deviancy, and this will be useful to study cases where women appeared as jurors, as to see what sort of, if they do also have biases as well that might perhaps be more in favor of women. However, most come from the early to mid 20th century, because there were supposedly fewer female jurors in the past. Part 3, or the final section, or just essentially continuing on the American conceptualism, titled Rape, the Quintessential American Crime. So it's inseparable from history of slavery and the legacies of racism. In Martha Hode's White Women, Black Men, published in 1997, said 2/3 of men indicted for rape or related charges in the 18th century were black, Indian, or transient foreigners. Furthermore, Black's study, or a block study, showed 80% of men accused for rape in early America were black, and 95% of accusers were white females. Often, as one might hypothesize, were the men causing their wives to convict someone of rape. And little changed in the 20th century, where 90% of men executed for rape between 1930 to 1964 were African American, which is clearly much larger than the African American population in the United States. Vivian M. L. Miller's Crime, Sexual Violence, published in 2000, showed that lynching for rape accusations were an extension of white terrorism. And I often think of To Kill a Mockingbird, where they try to lynch this black individual, and very great movie as well, very important movie. And book, of course, as well. Prior was a book. Vivian said this varied over time. For example, the higher value was before, when slavery still existed, there was higher value for the slaves' lives. However, and this was higher than the concern for white womanhood. However, after the emancipation, there was an increase in lynching because they no longer had ownership of these individuals, and therefore their prioritization of white womanhood was increased. Therefore, there's also been this clash between race, which has been more important, a larger cause, race or gender and race, and this has been underlined or caused by political or intellectual causes. Estelle B. Friedman, in her Redefining Rape, published in 2013, says that gender and racial justice have been divided, and, for example, so they're two separate fields, gender and racial justice, and therefore the African American woman has been the least studied victim of rape. However, they are exceptionally vulnerable and yet exceptionally rarely reported or written on too. So, in terms of the conclusion, so where to from here? Striking a chord for future research. So, Friedman's work, published in 2013, her book acknowledged Brown Miller's book as an influence to subject anew, and Lizzie Seal's on representations of women murderers in the 20th century. Britain acknowledges her debt to Hartman. However, nonetheless, significant shifts have occurred. So, essentially, although these scholars are drawing from other scholars, there's been much shifts over time. In the early 1990s, for example, scholars emphasized the class in reaction to norms of femininity in historiography of women who kill, but ethnicity, race, sexual identity, and nationality have become standard filters through which to view these through. Although racialized rapist remains distinct, and the doubly deviated murderesses appears finally dead. So that's one positive aspect, but so there's been race has remained a problem perhaps, but the doubly deviated murderesses appears to be dead. New possibilities from mass digitization as well of historical records, which have taken off since the proceedings of the Old Bailey online became searchable in the 20th century. Friedman says, for example, could not have conducted the large-scale data analysis of trials involving adult males and underage females until local U.S. newspapers became available online. So digitized resources are assisting in this. Murder and rape requires a fearless and faithfulness. For example, it requires a readiness to consider women who killed as capable murderers. So you have to be willing to see the possibility that they are perhaps did not have good intentions. For example, to document cases where women raped males must be studied. Also to study falsely accused males, as well as incorporate motivations of men to be ready to punish fellow men and embrace unwritten script of male solidarity. Furthermore, more study of post-conviction dispositions should be researched. She says, in capital cases, death sentence pronouncement was the prelude, not finale, to the process of criminal justice, so what happened after these convictions. Furthermore, rape in war is an area for study, whereas beyond the confines of civilian justice, so perhaps a different case to check the underlying tones of femininities and masculinities. The biggest contribution would be when demonstration of historical variability of seemingly intractable crimes such as murder and rape. Some are conducive to be commissioned, and some have caused mitigation. Furthermore, research into institutions, policies, and customs, and whether explicit or not, gender pervades all these patterns, she says. She finishes off this chapter with a metaphor. She says to think sonically, that is through music. And she says there are not just two intersections, so in terms of intersectionality, don't think of two streets, just race and gender, for example. Whereas Jeremy S. Begbie says, she quotes saying, sounds can occupy the same space while being audibly distinct, unlike visuals, so there can be many different tones going on here, a pluralism, and comparative studies of gender and crime widens further by doing this. The challenge for the future of criminal justice researchers would be to analyze the historically dynamic interpretation of gender amidst the changing timbers and accents of power. So that is the chapter by Carolyn Strange, Femininities and Masculinities, looking backward and moving forward in criminal legal historical gender research. To move to the content of the slide, in the top left we have the symbol of the Australian National University, where she is currently teaching. To the right we have the University of Rutgers, or Rutgers University, where she received her PhD. To below that, to the left, we have the University of Ottawa, where she received her Masters of Arts, and to the right of that we have the University of Western Ontario, or Western University, where she received her Bachelor of Arts. Below that we have the University of Toronto and York University, both in Toronto, Canada, where she was a visiting professor. Her institution, the Australian National University School of History, where she is a professor. Research interests: history and philosophy of law and justice, North American history, culture, gender and sexuality, law and society, courts and sentencing, criminology, Australian history excluding Aboriginal and Torres Strait Islander history, and history and philosophy of music. Suggested reading: The Penalty and Sex Murder in Canadian History, University of Toronto Press, published in 2020. As per the quotes, law demarcates, law bifurcates, slicing the impermissible from the permissible. Simultaneously, it designates who may and may not enjoy its protections and suffer its consequences. And next quote, certain laws on the books make explicit sex distinctions, but gender norms find their way into law's application and its language of putative neutrality. Next quote, the unique colonial and national history of the U.S. makes it an outlier in history of murder and rape. And final quote, this then is the challenge for future criminal justice researchers, to analyze the historically dynamic interpretation of gender amidst changing timbers and accents of power. So that is the chapter by Carolyn Strange, and we'll get discussion more in the comparison with Angela Fernandez. So Angela Fernandez chapter is also in part 2, Approaches, Conceptualizing Legal History, titled chapter number 14, History, Legal History as the History of Legal Text. So a little bit about Angela Fernandez. She's a full-time professor at the University of Toronto, Faculty of Law, since 2020. Before that, she was an assistant professor from 2004 to 2009, and associate professor from 2004 to 2020, or 2009 to 2020. Or before that, she was an assistant professor. She has a cross appointment in the Graduate Department of History at the University of Toronto. She received her Bachelor of Arts with an honors in philosophy and a minor in women's studies from where she was the Prince of Wales Gold Medalist at McGill University. She received her Master of Arts in philosophy at Queen's University, and she received her Bachelor of Law and her BCL, or Bachelor of Civil Law, at McGill Faculty of Law, and her Master of Law at Yale Law School, and her JSD, her Doctorate of Judicial Studies, at Yale Law School as well. Her thesis was spreading the word from the Litchfield Law School to the Harvard case method. Litchfield Law School is the oldest law school in the United States, and College of William and Mary. Her book is titled Pearson v. Post, The Hunt for the Fox, Law and Professionalism in American Legal Culture, published by Cambridge University Press in 2018. She's a member of the Brooks Institute for Animal Rights, Law and Policy, and on the board of advisors and the director of the Animal Justice Canada. Her research interests are contracts, critical legal theory, feminist analysis of law, law and literature, legal history, legal process, legal theory, and property law, and her specialty is legal archaeology, which will be the topic of this chapter predominantly. So, starting with, in her chapter, it says it's written at the University of Toronto, Faculty of Law. She says she benefited from presentation at the American Society of Legal History annual meeting in Toronto, specifically a commentary presented by R.W. Gordon. The author thanks the fellow panelists, especially David Sandomierski, for organizing the session and for his comments and suggestions for the chapter. And thanks to the editors, Marcus D. Dubber and Christopher Tomlins, for the editorial direction and feedback, as well as the workshop coordinated with a handful of the other contributors to the textbook in May of 2017 at the Center for Ethics at the University of Toronto Faculty of Law. She also thanks the University of Toronto Law research student Colin Romano, who provided excellent assistance with formatting the footnotes and editing and substance suggestions. So she opens up her chapter titled Legal History as the history of legal texts, saying, this chapter provides an overview of legal archaeology as just one example of legal history as the history of legal texts. The casebook, she says, the casebook case is the unit of analysis, the legal text in question, so focusing specifically on legal archaeology relating to the casebook text. She argues history should be approached in a variety of internalist ways, and that places the person at the heart of this approach, creating a prosopography of the common law in a law school curriculum. Very challenging word. I don't know if I'll ever get that correctly, but John T. Noonan, she starts off referencing John T. Noonan's Persons and Masks of the Law, published in 1975, that cases were an occasion for the production of law, but risk becoming morally problematic masks, disguising the humanity at the heart of the law. So, a little overview of what's about to happen is she really goes into casebooks and says it's kind of become, once a casebook is there's a lot of missing context, like what is included in the casebook, or what is not included in the casebook, which casebooks are included and which cases are not included, and how this varies across geography, and all these sorts of very fascinating concepts. She references Richard Danzig and Jeffrey R. Watson, 1975, The Capability Problem in Contract Law, where the capability problems describe an occlusion of what happened to parties before, during, and after a case was heard and report made for the legal system. So what also happened before and after legal text, making it a legal archaeology. Elizabeth Mertz, The Language of Law School, published in 2007, says they're often seen as detachable chunks of discourse, and they're supposedly irrelevant and excised from the classroom. So a lot of these important details that she endeavors to unravel and promotes others to unravel have been excised from the classroom. So the casebook writers generally are positivistic, asocial, and anti-contextualist, and they don't focus significantly on the life of the litigants. Noonan, in his Pulsegraph v. Long Island Railway, showed that Mrs. Pulsegraph's injuries were made invisible by Justice Cardozo and Andrews for the development of their own legal doctrine. So sometimes there are certain things hidden, but you wouldn't realize this unless you knew about Justice Cardozo and Andrews. Furthermore, therefore, there's the one side, litigants have been considered the sacrificial lambs in this case. And then in Danzig's writing, Hadley v. Brendale, the brother of one of the judges was a managing director of the courier company Pickfords before Mr. Baxendale. So there's underlying history, and that's why she also advocates for focusing on a people-centric view, which I endeavor to capture through these videos, where I focus more on the individuals rather than the specific concepts. The case still is the primary unit of analysis, but investigations of how cases come to be included in casebooks are few and far between. For example, questions that are important are, why are some cases included and others not? What were editors thinking when they dragged one out of there from obscurity? So you have to, it's an interesting thought experiment that if a case wasn't put in a textbook, it would essentially, very few people would actually have read it. And did weight of past practice dictate their continued inclusion, or what other factors were at play? So why wasn't it ever taken out, or why was it kept there? Why was it shifted in place? Did they actually become more useful, or was it a strange kind of deference or inertia that made them continuously read and discussed? So her specific work on Leaf v. International Galleries, which covers a 1950 British mistake case regarding a John Constable painting. I also think, off topic, but Marianne Constable is another video that I've covered, a different scholar, but this John Constable in this case is a painter. So in Leaf v. International Galleries, which is a 1950 mistake case regarding a John Constable painting, it's included in most commonly used textbook at the University of Toronto Faculty of Law. However, the book started by this casebook was started by the founding dean Cecil Wright of the University of Toronto Faculty of Law, and it was included later, however, by the University of Toronto contracts teacher in the 1950 James B. Milner. But Leaf was not a famous or leading case and generally not taught in the U.S. So Milner, one of the contracts teachers, made this decision to put it in the textbook, and then it became the most commonly read textbook in the University of Toronto Faculty of Law just by this one intellectual's decision. Therefore, her research led to observations about Milner and the inclusion process. So what were the motivations behind Milner, and what was Milner thinking? And also what was the handover process from Cecil, the dean, to Milner of this textbook. For example, did Wright want Milner to include this, or would that have been his vision? Or was he still influencing Milner? Legal scholars increasingly become comfortable about speaking of what's called a canon of cases and casebooks, equivalent to Norton anthologies of English and American literature, and one might call them anthologies of the law. So there's these major cases that everyone must read, and there's also it's important to note there's an anti-canon. For example, infamous U.S. constitutional cases such as Dred Scott and Plessy v. Ferguson, alongside collusive cases such as Buck v. Bell and notorious property cases Johnson v. Mintosh, or particularly harsh contract cases such as P.V. House v. Garland Cole. So there's also anti-canon as well. Her own work on property law case Pearson v. Post, it includes a focus on how a case was anthologized in the U.S. property casebook in the 20th century and appeared in over 700 law review articles, particularly in the 1980s. Placement in casebooks, is important. For example, is a case put at the beginning or put at the end has a big influence on how it influences common law countries. And other considerations that are covered in this book as well is the Latin of the majority decision translated, which perhaps puts a little bit of a barrier for some people reading it. Furthermore, what ways do notes and questions accompanying the edited selection nudge or blatantly direct the reader? So how has this changed over time? So very important. There's clearly ideological undertones in supposedly neutral casebooks. Treaties or restatements bend heavily towards normative when purportedly merely descriptive. So there's an argument that she makes with Marcus D. Dubber that it's almost impossible to view any treatise as merely descriptive. And I think from my logic, why would someone create a treatise if it was completely made to be descriptive? One would just go read the case, whereas a treatise has to provide something new and it's therefore and has some sort of bias, likely. Simpson notes says common law rules enjoy whatever status they process not because of circumstances of their origin, but because of their continued reception. So a lot of cases continued to include additional relevant people to keep the case relevant. So these cases keep having to get updated to remain a part of the law, otherwise they'd be forgotten. So there's also this driving force. So how did it intersect change over time and morph and bend? interests change over time, morph and bend, and how did a case appear in a different legal systems with different histories and or social and political contexts. So often there's the, and this is all concepts of what she calls the internalist approach, internal history, looking at law's own, or what Bob Gordon in his lecture said, the Mandarin materials. She's not committed to, however, this is not, by looking at this internal approach, it's not committed to telling a Whiggish story and looking for purity and improvements. However, it accounts for a mixed and multifarious changes over time. So you don't pick out and choose what to include in the history of cases. And therefore, externalities may ignore or even downplay self-serving speech of the legal profession. Or externalists may say that the internalist approach downplays and is self-serving speech of legal professionalism, so it could be seen as doctrinalism, focusing too much on the case. However, a lot of these things don't stay internal and expand into, for example, these become intellectual history, which is also a broader and more external-looking field. The internalist approach to case in context studies more readily associated with public law, but it also still relevant in private law too, because private law has politics as well. And furthermore, it's also relevant in international law as well, such as the UK, United States, Canada, Australia. There's been inheritance between these geographies, but also transplants, and also it's important to note the contradictions between, for example, some cases are read in one country, but some cases are not read in other countries. Legal archaeological studies studies what is mainstream in the 2000s. Foundations Press republished Danzig and Watson's collection in 2004, have what they call Law Stories series. So legal archaeology studies became mainstream in the 2000s when the Foundation Press republished Danzig and Watson's collections in 2004. So that's when Angela Fernandez says legal archaeology likely began, or was the kind of the critical point. But she does not see this study abating. For example, the UBC Press created the landmark Cases in Canadian Law, which is in which the series promises a canon of important but not necessarily well-known cases, and as well it will document changing understanding of notoriety and fame over time. So an important growing or indication that there's growth in this area, legal archaeology. Furthermore, legal archaeology is expanding the frame of legal history itself. For example, and she references that there's a underlying motivation for this. For example, Ancestry.com, she says people are interested in the people related to cases, so there's continuous research into this. And she says some people even almost have work on Ancestry.com like a full-time job, somewhat facetiously, but perhaps partially truthfully. Furthermore, there's been a new call for a kind of prosopography. I'll still mess up the word. Not just focusing on the heroes behind the cases. A.W. Brian Simpson's biographical dictionary of common law, published in 1984, which presents short descriptions on many different important legal scholars, is often also an indication that there's a people-focused motivation behind a lot of the scholars. And like I myself, that's how I learn, that's how I present this video series focused on the legal scholars. Furthermore, the internalist approach refuses to take timelessness as a fact at face value. Some externalists might say that it is conservative and self-serving tendency, but it must not necessarily be this internalist approach. If it eschews the internal and fails to appreciate how conservative the profession really is, so you have to look at the good and the bad. So you have to study why, or the fact that it is conservative, to actually, if anyone would hope to mitigate it. She has 3 hopes. 1, to look more into race, gender, and class prior to the 1980s, particularly posthumanism, Anthropocene, and also into the non-animal area, which is one of her specialties as well, in addition to legal history. She has classes on it at the University of Toronto Faculty of Law. Furthermore, she would like to recontextualize and expand insights of law and literature, which Simon Stern, another professor at the University of Toronto, and I created a video on, also specializes in. And also she would like to study changes from book to digital format and how that has affected the legal archaeology. Noonan says the state and transparent or legal texts are change the view as signifiers to signifying as fluid. So one shouldn't just focus on the case and say, what does this signify, but look at what the signifiers behind the case that lead to its overall meaning. She says it can be some of the research might be inglorious. For example, the English judge Lord Denning was clearly a racist, as well as many of the feminists crusading for female rights, particularly the famous five, were pro-eugenics and often quite racist. So although you might have to tarnish some people's images, it's important still to engage in this area of research, and she says you must be fearless. In regards to law and society, Roscoe Pond, in his Law in Books versus Law in Action, makes a distinction between this, and which would, on face value, decrease the value of legal archaeology. However, she says, as in addition with Marcus D. Dubber, that they can recall it law books in action. So there's an application portion to this area of research. It can often be a subjective area of research. So what is considered great, what should be included, and for example, she focused in Pearson on gender, violence, and animal status, as well as slavery and colonialism, and therefore expanded from internal to external. But it's often up to the actual scholar to choose what to focus on, but the point is that they all must be researched. Pedagogical or teaching case is the same as common law in the common law school curriculum. Tapping Reeve at the Litchfield Law School, for example, used the law school and treaties, which was some of the first, perhaps the first treaties in American history, to convince students to change laws and permit women to make wills. So that was her actual thesis it was about, but also the point is that don't just look at the case books that the individuals were reading, but look behind the professor and how the professor was influencing the students, and as well the treaties as well, which, as we noted, there's almost no completely non-biased treaties. And therefore behind the people, and also one which question, was it right as well, so also question the morality as well. E.P. Thompson says the greatest of all legal fictions is that the law evolves from case to case by its own impartial logic, true only in its own integrity, unswayed by expedient considerations. And there, where expedient considerations such as politics, social contexts relating to uptake and circulation, and therefore there's inevitably external factors affecting the internal. So it's not that the internal is strictly focused on the internal, it's more just a bottom-up. I should use the term first principles. Therefore, also the question, what is relevant versus what is just more detail? Lawyers and judges in most positivist mode reassert singular meaning to cases, often form a doctrinalism, and it goes back, and however, she says it goes back and forth. So even though they might be focused on a singular meaning, the fact that there are multiple meanings shows that there's a dialectic or dialogue about what is important and not. And dialogue, as a contrast, monologue, that is where you find key findings, that's why also previously mentioned, that's why I structure these books in the style of, or these lectures in the style of Plutarch's Lives, by studying two people side by side. That's where I really get to learn more about them overall. Furthermore, technology may open up education. So for example, people, when they research case books, rather than looking at their textbook, they might find alternative meanings. But she says, if I am right, there will always be law professors keen to package and present. So even though there might be an opening up of this area of research, the professors will always kind of sort of direct the field. and therefore there will always be packaging and presenting to be studied by legal historians. So that is the chapter by Angela Fernandez. I think a very area of research, legal archaeology. Also, she's very influential in the field of legal animal rights or animal rights law. So moving to the slide, in the top left image we have the symbol of the University of Toronto, where she is a professor at the Faculty of Law. To the right of that we have the Yale Law School logo, where she received her Master of Law and her Doctorate of Judicial Studies, SJD. Below that, to the left, we have the logo of McGill Law School, where she received her Bachelor of Arts as well as her Bachelor of Common Law and Bachelor of Civil Law. And in between that, we have to the right of that, we have the Queen's University logo, where she received her Master. She is institution, the University of Toronto Faculty of Law, position professor, and as well she's the director of Animal Justice Canada. Research interests: contracts, critical legal theory, feminist analysis of law, law and literature, legal history, legal process, legal theory, and property law. To the quotes, and some of these I have already said, but bear with me. I argue that casebook cases can and should be approached in a wide variety of ways, termed here internationalist. This is a form of legal history that places persons at the heart of its approach, creating a kind of prosopography of the common law of the law school curriculum. Still mess up that word, my apologies. It is clear that legal scholars have become increasingly comfortable speaking about a canon of cases and casebooks as the equivalent of Norton anthologies of English or American literature, the anthologies of law. Next quote: it would probably be fair to say that the legal archaeological study of cases went mainstream in the 2000s. Next quote: once leading cases or teaching cases enter the jurisprudential firmament or the canon, or however one wants to put it, they tend to stay. So it's an important area to kind of deconstruct why they got there and perhaps what the meaning behind that was. And if I am correct, there will always be packaging and presenting for legal historians to study in the form of persons in the legal process. So, suggested reading: Pearson v. Post, The Hunt for the Fox, Law and Professionalism in American Legal Culture, published by the Cambridge University Press, 2018. So also another very, very fascinating intellectual in the legal history space. So that is her chapter. Moving to the comparison between Carolyn Strange and Angela Fernandez. So they both do research in feminist legal studies. However, Carolyn Strange specializes in this area, whereas Angela Fernandez is more focused on legal archaeology and as well as the law of animals. Furthermore, Carolyn Strange is a professor of history, however, that she has taught at law schools and taught law courses. However, Angela Fernandez is a law professor and has studied law. So Carolyn Strange actually did her doctorate in history, whereas Angela Fernandez did her doctorate in law. And Carolyn Strange actually does not have a law degree. Furthermore, Angela Fernandez practiced or did some clerkships, for example, at the Supreme Court of Canada. They both have had education in Canada, such as Queen's University, Western University, McGill University. However, Carolyn Strange is ultimately an Australian professor, and Angela Fernandez studied in the United States, so different geographical backgrounds. Lastly, their chapters were quite different focuses in that Carolyn Strange was focused on rape and murder and criminal law, whereas Angela Fernandez is more focused on animal law, in which she's the director of Animal Justice Canada. So that is the biographies and chapters of Carolyn Strange and Angela Fernandez. I hope you join and continue to support. Thank you so much.